Good evening to the participants of the JCJ 2022, the main examination, which is scheduled to be conducted on 26 November 2022, if it is not postponed. Yes, karibu sana, welcome to my class in the Kiswahili, and read what I posted on the screen.
Code of JCJ 2022 main examination, code of civil procedure, other definitions, affidavit, suit, plaint, written statement, affidavit, order 90, contents of affidavit, false affidavit, meaning of suit, plaint, necessary contents of a plaint. Professor Dr. Mohammed Saheb Hussain.
Yes, that is the thumbnail that I put it over there. Now let us, without wasting the time, let me go to our online class, that is other definitions: affidavit, suit, plaint, written statement. Now let us discuss what is affidavits. It is order 19, but when you write the order 19, I believe that you should not supposed to write in that way. Am I right? Then what should be written there?
In Roman letters.
Yes, what are the things comes in the Roman letter?
Double XI, sir.
Double X 19.
XXI.
19 means 1x. This is 19. Am I right?
Yes, sir. Yes, sir.
Okay.
Yes,
Now, affidavits are dealt under the Order 19 of the Code. It is a sworn statement made by the person who is aware of the facts and circumstances which have taken place. The person who makes and signs is known as a deponent, spelling DEPONENT. The deponent makes sure that the contents are correct and true as per his knowledge, and he thereby concealed no material therefrom. After signing the document, the affidavit must be duly attested by the oath commissioners or the notary appointed by the court of law. But in practice, what will be the practice? Do you know it? The notary will sign it, later on the deponent will be taken the signature. Of course, that is a different issue. It is behind the screen. So now let us see that affidavit means a sworn statement of the deponent. A person who makes such a statements are true and he will not hide anything, bring to the notice of the court, but with the attestation of the notary, he will say in India, but in other countries like Tanzania, we will say the commissioner, the oath commissioner, commissioner of oath. That is the wording that we use it, nomenclature. The person who gives attestation to the affidavit shall make sure that the sign of the deponent is not forged. The affidavit shall be drafted as per the provisions of the code. It must be paragraphed and numbered properly. Can you write the affidavit in Telugu language, which is the state of Telangana? Answer is?
Sir.
Could you write the affidavit in Telugu?
Write in English.
As per my knowledge,
No, sir.
English. Speak.
Generally, we write in English, sir, because code language is English only, sir.
Yes, the court proceedings are in English generally, and hence the affidavit should be the English language. Suppose the court proceedings are in other than the language, English, then at that time I believe it can be entertained. But as for of course, the state government rule is concerned. So even though the affidavit has not been defined in the court, it basically means, I quote, a sworn statement in writing made specifically under oath or affirmation before an authorized officer or a magistrate. So that is then when affidavit would be there, it will be filed in the court of law. Then what are the essentials of the affidavit? There are some basic essentials that are required to be fulfilled while submitting the affidavit in court. Read the first bullet.
it must be a declaration by a person.
Good. Second bullet.
It shall not have any interferences. It shall contain facts only.
Good. Third bullet.
It must be person.
Okay.
It must be in the first person. It must be in the. It must be statements that are taken under oath or affirmed before any other authorized officer or magistrate. Contents of affidavit.
Yes. When you say it must be in the first person, what it means? If you know it, you
It
tell me. If you
means
don't know it, you say spasa.
it will be like the person is saying, sir, I, Rosia, solemnly affirm a
I
statement like
appreciate. I
this, sir.
appreciate. If you're not supposed to write he, she, third person singular.
Yes, sir.
So that is the way the
Yes,
first
sir.
person should be written over there. So it must be a statement that are
Seeing
taken.
that,
Yes.
yes, sir.
Go ahead.
After seeing the affidavit, court will feel that the person itself is speaking to the court by
Okay.
through affidavit.
Okay. Appreciate. Appreciate. Then, as per the rule 3, an affidavit shall contain only those facts to which the deponent is aware of as true to his personal knowledge. However, interlocutory application can be filed wherein he can admits his belief. Of course, IA would be filed over there later part, which he feels, suppose something is missed in the affidavit, he can entertain it later in the form of IA. Am I right?
Yes, sir.
What is IA?
Interlocutory application.
Is it an abbreviation? It is an acronym? It is a contraction? It is a shortening form?
Shortening form, sir.
Wrong. I say IA. I spelled both the letters individually. Hence, it is initialism. Only the initial words are pronounced. Is it correct?
Okay, sir.
Yes, why you have forgotten? Already you have once given the reply for that one. Okay, let us come to the point. Evidence on affidavit. As per the Section 3 of the Evidence Act, affidavits are not considered as evidence. When there is a need to prove the facts, oral evidence is normally taken into consideration by the court. However, Rule 1, Order 19 is invoked by the court when it finds that it is necessary to make an order for any particular fact which may be proved by affidavit. At that instance, affidavit will be based. If a person provides evidence under the affidavit, then the opposing counsel has a right to cross-examine or reply in affidavit. Both the way it can be done. Either the opposite counsel may cross-examine or it can be reply what is given in the affidavit, whether it is true or wrong or whatever it may be. Further, the person who is making an affidavit shall put on those facts only to which he has a true personal knowledge. So, a person who executes the affidavit is called
Deponent, sir.
I appreciate. Good. If he gives a statement not to his personal knowledge, then such a case he shall mention the true source. In case if he could not or she could not know it, if it is knows the true source is there at the time, he or she can make such a statement in the affidavit. The counsel shall advise the deponent to make sure that he or she puts the fact which he knows rather than what he believes. So, believing is not the point, what he knows is the more point. Is it clear?
Yes, sir.
Good. The court can reject the affidavit if it is not properly verified and not in the conformity with the rules of the court. At the same time, the court can also give an opportunity to the party to file a affidavit properly. In case the affidavit is not written in a proper form as per the court, then the court can return the affidavit and ask the deponent to produce it, file it in a proper form. So that is clearly mentioned. Then in the interlocutory application like the interim injunction, the appointment of receiver, attachment of the property, wherein the rights of the parties are not determined conclusively, can be decided on the basis of the affidavit. So, affidavit basis can be made if it is the appointment of the receiver is necessary, or the property should be attached, and whom should be appointed for the attachment, and who will execute it, that it will be decided by the court based on the affidavit. So, what is the false affidavit? So, false affidavit says under section 191, 193, 195, 199 of the Indian Penal Code 1860, it says filing a false affidavit is an offense. So, giving a lenient view will undermine the value of the document, and it will harm the proceedings and will provide no justice to the parties. So, criminal contempt of the court proceeding can be initiated by the court against the person who files the false affidavits in the court of law. Strict actions are taken against the public officials who files false affidavit. If it is filed by a public official false affidavit, an action would be taken by the court to the public official. If the affidavit is executed or presented to the court by the deponent, even deponent will be taken an action against him. And means court will take an action against the deponent. Is it clear?
Yes, sir.
You read as per the section 193 of the IPC. Read.
A person who intentionally gives false evidence or fabricates false evidence during a judicial proceeding, he shall be punished with 7 years of imprisonment and fine.
Yes.
And whoever intentionally gives or fabricates false evidence in any other case shall be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine.
Yes. Either the two options are given over the two things. Either for the 7 years imprisonment and fine, or the 3 years and shall be liable to be fine also. Who? A person who files the
Who
false
gives
affidavit in the court
evidence.
of law. And which sections will say it is a false affidavit?
191, 193, 195, and 199 of Indian Penal Code 1860.
Yes, it is clearly mentions what is the false affidavit. So, meaning of a suit now. The word suit has not been defined anywhere in the code, but it is a proceeding which is commenced by a presentation of a plaint. In Hansraj, Gupta, and others versus official liquidators of the Dehradun, that is in Mussoorie Electrical Tramway Company Limited, the Privy Council has defined the expression suit as a civil proceeding instituted by a presentation of a suit. It is called the suit. Can you tell me what is the difference between a suit and OP, original petition?
Suit is relating to immovable property, sir.
Okay.
OP may be MVOP is there, motor accidents. HMOP is there for family matters, sir.
If the claim is there,
So suit is
mostly the monetary, and somebody will be liable to pay or to undergo. At that instance, we can say it is a petition, OP, original petition. In suit, it is filed regarding the rights are concerned or an offense is made under the penal code.
no,
Because
sir. For
of
offenses,
course, the penal
those
code
which are not
false
used
may be
in
there.
matter.
Yes, you can make it in the civil cases also. This thing will be happen. So that is the little difference between the suit and the OP, original petition. In Panduranga Ramchandra versus Shantibai Ramchandra, the Supreme Court has stated suit is to be understood to apply on any proceedings in a court of justice by which an individual pursues the remedy which the law affords. Where a individual will provide the remedy where the law affords, generally that we will say suit. So OS will say original suit. Am I right?
Yes, sir.
Now let us see what is the plaint. A plaint is a legal document that contains the content of any civil suit which shows the plaintiff's claim after filing a suit. The plaintiff is the first step of the plaintiff in the form of legal document for the commencement of a suit, and it shows what a plaintiff wants from that suit. The concept of a plaintiff is mentioned in the Civil Procedure Code. Though the help of the plaintiff narrates or describes the cause of action and related information, which is considered as an essential from the viewpoint of the suit. So, a suit comes at that instance only when the plaintiff files in the court of law. Am I right?
Yes, sir.
And in the case of the plaintiff, the cause of action consists of the two divisions. What are they? First, the legal theory, the factual situation based on which the plaintiff claims to have suffered, and second is the legal remedy that the plaintiff seeks from the court. So first it will show it is a offense based on the facts what he committed, and second point it will show that what is the remedy that he wants from the court and what the plea from the court by the plaintiff, the plea of the plaintiff and prayer of the plaintiff, that is a legal remedy available in the court of law. So that also will be clearly mentioned. A plaint is considered an important concept because it is the foremost and initial stage to initiate any lawsuit and helps to find a civil court of appropriate jurisdiction. Again, that comes in the filing the suit, then we'll see that appropriate jurisdiction is there or not to the court to entertain such a case, because sometimes pecuniary jurisdiction also plays an important role. Am I right?
Yes, sir.
Good. Order, what is this? 7 of the Code of the Civil Procedure deals particularly with the plaint. So the Civil Procedure Code of the Order 7 will deals in Order 7 of CPC. Yes, in Order 7 of the CPC, there are many different rules which deal with the different constituents of the plaint. So Rule 1 to 8 in Order 7, Rule 1 to 8 deals with the particulars of the plaint. Rule 9 of the CPC, again 9 should be not written in that fashion, because the 9 which is shown here is Arabic number, but it should be a Roman number. That means 1x or ix capital of the CPC deals with how the plaint will be admitted, and of that Rule 10 to 13, not Rule 10 to 10 capital B, talks about the written of the plaint and the appearance of the parties. So 1 to 10b, it gives a different mode where the rules are framed and how the plaint should be, the written of the plaint and the appearance of the parties. And the main rule, that is Rule 11 to 13, deal with the rejection of the plaint when the plaint is not in a proper order or under the rule, and in which circumstances the plaint can be rejected. Who rejects the plaint?
The court will reject, sir.
Good. Sometimes now before it reaches the court also, can the superintendent can also reject if it is not in the proper form?
No, sir, it must be signed by the presiding officer of the court while it.
Okay. Appreciate. Section 26 of the Code of the Civil Procedure states, I quote, every suit shall be instituted by the presentation of a plaint on which such other manner as may be prescribed. So there is a particular procedure would be there where you can write the plaint and submit the plaint and make a suit. This section clearly shows that the plaint is very much necessary for the establishment of a suit. So if you want to file a suit, the plaintiff is must. Am I right? Say yes or no.
Sir? Yes, sir. Yes, sir.
What is the sequence? Tell me from the beginning. Number one, first plaintiff. Number two,
Plaintiff, sir.
plaint.
Written statement. Summons, sir. Summons.
Of course, that is the sequence. But here, the first one is the plaintiff, next is the plaint, next is the suit. So it's very much necessary for the establishment of a suit before the civil or commercial court. Commercial court also comes under the criminal or civil.
Civil, sir.
Good. So necessary content of a plaint. How a plaint should be. What are the contents of a plaint? A plaint is a legal document that contains a lot of necessary contents, in the absence of which it cannot be considered as a plaint. So the plaint having certain conditions, based on the conditions only you have to write the plaint. The contents necessary for a plaint are mentioned in Rule 1 to 8 of Order 7 of the CPC. How a plaint should be there, it is framed in Rules 1 to 8 of the Order 7 of the CPC. These are mentioned below. Read the A plaint. A. Munira, are you there?
Sir.
Read
Plain should
8.
A. Clause A. Plain should contain the name of the commercial or civil court where the suit will be initiated.
What it means?
Above heading plaint heading should be the court name which it was getting
In
instituted,
which
sir.
court the case is going to be filed?
Yes, sir.
B.
B. Plaint should contain details of plaintiff such as name, address, and description.
Yes, of the plaintiff. Can the age would be written over there?
Sir?
Sir.
Son of, daughter of,
Son.
Yes, sir.
residence
Yes,
of,
sir. That has to be
because that comes under
residence,
the address.
religion, occupation. No, Aadhaar number is also asking, sir.
Okay. Means regarding the plaintiff, every detail should be mentioned over there.
Yes, sir.
Number C. Plaint should contain the name, residence, and description of the defendant also. D. When a plaint has some defects or problems in health or any types of disability, the plaint should contain the statement of these effects. Suppose the plaintiff is a physically handicapped or visually handicapped or mentally handicapped, this should be clearly mentioned in the plaint. Am I right?
And if minor, if defendant is minor, that has to be mentioned in the
Yes, even a minor also you should have to make it out, because a minor, a friend should be there and who is a guardian and he will file the case on behalf of the minor.
minor.
So the plaintiff should contain the statement of these effects. So whatever the quality of the plaintiff, if any disability is there, health effects are there, that should be clearly mentioned in the plaint. E. Plaint should contain the facts due to which cause of action arises, and where the cause of action arises, it should also be mentioned. What is meant by cause of action?
A bundle of facts, sir, which showing a relief to plaintiff.
Is it based on the offense or not?
Sir?
Based on the offense,
Yes, sir.
and where the offense also committed.
Yes, sir.
That is to say, the cause of action arises, it should also be mentioned. Means where the wrong or fault or a breach or any other thing which a plaintiff wants in the prey, where it is happened. It should be also be mentioned. F. Plaint should not only mention facts due to which the cause of action arises, but also those facts which help in recognizing the jurisdiction. So both the things would be there. Where it's recognized the jurisdiction, which court is having a jurisdiction to entertain such a case, and that also should be described over there. If it rains in, say in Khammam, can you open the umbrella in Warangal? Answer
No,
is,
sir.
where it rains, you have to open the umbrella there. In the same manner, where the cause of action arises, there only you have to file a suit.
So, yes.
G. Anyone can unmute and read G. What
He
is
said,
G?
plaint should also contain about the relief which a plaintiff seeks from the court.
Yes. What is the another name for the relief? Can you say prayer?
Yes, sir. Prayer, sir.
What he needs actually, what the relief he wants, what the remedy he wants from the court for the cause of action which arose in particular jurisdiction.
It is a issue of fact, sir.
Read H.
When the plaintiff is ready to set off a portion of his claim, the plaint should contain that amount which has been so allowed.
Yes, if something the set off is there, that is due or some other thing would be there, it should be also clearly mentioned in the plaint. So contain the amount which has been so allowed. How much be allowed to set off? Set off means need not to pay. Am I right?
Yes, sir. Partial amount which. Yes, sir. Yes, sir. For this amount, he further cannot file a suit, sir, for
Yes,
set off
once he
amount.
set off, he cannot ask again for that thing. Suppose if he waived it.
Yes, sir. As per order 2, rule 2.
Okay,
Commission.
okay. Can the oral waiving also considered?
Oral waiving is not considered, but it is in plaint now, sir.
Suppose if he produced the two witnesses, corroborative,
Maybe, sir. Don't know.
because anything orally difficult to prove it, hence everything should be in black and white. So the last part is I is plain should contain a statement of value of the subject matter. What is the subject matter? Its value of a suit, not only for the purpose of jurisdiction, but also for the purpose of court fee, because it depends upon the value, and you have to pay the. You have to pay the. Is it a stamp duty?
Court
Is it a
fees,
court
sir.
duty?
Court fees, sir. Court fees act is
Court
there.
fee.
Court fees.
Stamp duty will pay it when you are registering a house.
Yes, sir.
At last, the content that should be on plaint is the plaintiff verification on oath. So whatever the plaint would be there, and the plaintiff is the responsible. If it is affidavit, you will call the deponent. Is it not?
Yes, sir.
This shows that the plaint is necessary component for the successful initiation of the suit. So what is essential condition as the component should be there in the suit means plaint. Either it is a commercial or a civil court plays a very important role throughout the suit. So in all the suit, the plaint is very much important. So when you are drafting the plaint, you should be very, very careful whether the CPC rules are followed or not. Am I right?
Yes, sir.
So some additional particulars which were not mentioned above include the following. Plaintiff shall state the exact amount of money to be obtained from the defendant has given under the rule order 7, whereas the rule 3 of the order 7 of the CPC states, then when the plaint contains the subject matter of the immobile property, then the property must be duly described. Whatever the property is there, that duly described. How do you describe the immobile property?
By the description north, south, west, like this, sir.
and the square meters or yards, whatever it may be there,
Dates
then the
and
sketch
bounds.
should be there,
Yes, sir.
and a surveyor makes the sketch,
Survey number,
and the survey number.
and
What is meant by pahani here?
Pahani is a revenue document, sir, which shows the possession of the person.
Means who is the owner of the property?
No, sir. Possessor is different from owner, sir.
Yes, what is the common law principles? Possession is 99%, ownership.
Than ownership.
So that is the point. So important concepts: res sub judice and res judicata. Section 10 and 11. Nature, scope, and objectives. The principle of res sub judice prevents the court from proceeding with the trial of any suit in which the matter is in issue is directly or substantially the same with the previously instituted suit between the same parties, and court where the issue is previously instituted is pending has the power to grant the relief sought. So, can the pending suit can be, if the suit is pending over there, at that instance, could you wait? What are the decisions comes over there?
Stay of suit, sir.
Yes?
Stay of suit, sir.
Okay.
Subsequent suit.
Means similar nature is again it cannot be filed. Is it?
Yes, sir.
Okay. Let us see it. This rule is applicable to the trial of the suit and not the institutions. It does not restrict the court from passing the interim order like the injunction or stay. However, it applies to revision and appeal. So, what is applies to revision and appeals? Is it the suit or an injunction order?
Sir, for this res sub judice, interim orders can pass the subsequent court, sir, in the trial. But however, in revision or appeals like this, these interim orders cannot be passed, sir. It was saying like that, no, sir?
Say that it applies to the revision and appeals.
No, sir. It applies to
Revision and appeals. The rule is applicable to the trial of the suit, not the institutions. It does not restrict the court from passing the interim order like the injunction or stay. However, it applies to the revision and appeals also. Means injunctions and injunctions, if it is passed over there, we can go for the revision or appeals.
Oh, okay, sir.
Anyway, let us check it. You read it again. See when it can be done and how it can be made. Check it once again. Subject to the correction, we can make it a what is the res sub judice. So the purpose behind this rule is to prevent multiplicity of the cases. See, when the case is pending over there, and the same thing again, it cannot be made because still it is pending. Nothing has come out. So one need not to again file a case. The purpose behind the sub judice is to prevent the multiplicity of the cases in courts. It also sought to prevent the plaintiff from getting two separate decisions from the different courts in his favor or two contradictory judgments. So the way when the case is pending over there, naturally other person cannot file a case in the different courts. Number one, it's a multiplication of the cases. Number two, the judgments are different, is a contrary. So it also ensures to protect the litigant from the unnecessary harassment. So unnecessary harassment can be made when it is sub judice, still pending in the court. The policy of the law is to restrict the plaintiff to one's litigation, thus obviating the possibility of the two conflicting verdicts by the one and the same court in the respect of the same relief. So to avoid the multiplication of the cases, it will be there. It will be. Then what is the lis pendens then?
Lis pendens is under Transfer of Property Act 52 section, sir. It is about during the pending suit or in case, the property cannot be transferred.
Okay. Because when we cannot dispose the property because lis pendens, because judgment is not come on. in favor of anybody.
Yes. Yes, sir.
So now let us see the conditions. What are the conditions should be there? Section 10 of the Civil Procedure Code 1998 deals with the conditions required to apply the principle of res sub judice. The conditions in the process of the application of the res sub judice are: number one, where the matter in issue is the same. When the issue of the matter, the subject matter is the same, the issue is the same, like the section 10 clearly states that the matter in issue in both the suits must be directly or substantially be the same. In other words, there must be two suits, one that is previously instituted and another that is subsequently substituted. So the matter is sub judice, the second suit cannot be filed. The issues of both the suits shall be the same to get the benefit of this principle. It is not sufficient if any one or two issues are common. Of course, majority of should be common. In the circumstances where the entire issues are not the same, the court may exercise its power under section 151 of this and stay the trial in the subsequent suit, or the trial of the suit may be consolidated. So the court is having the jurisdiction. How many issues are the same? How many are contradictory? If the issues are the same, then they consolidate it. All the writs of the same nature would be there. Then all the writs will be put together and one judgment will be given. Am I right? Yes?
Yes, sir.
Yes, sir.
For instance, High Court of different countries, they filed a court in the Supreme Court of India. Issue is the same. Can't they consolidate the Supreme Court of India? Answer is yes. To avoid the multiplicity of the judgments, the same judgment will be applicable to all the cases which is filed in different courts. Am I right? It is. The power of the courts to say the trial under section 151 is a discretionary in nature and can be exercised only when there is an abuse of process of the court and if it defeats the end of justice. If it defeats the end of justice, the process of the court would be there. Then at the time that the court is having the discretionary power to consolidate them all, or if it is found that different issues are there, then they can allow it to file a case, a separate case. Again, according to Indian Evidence Act 1872, matter in issue are of the two kinds. What are the matter in issue and how they are two kinds? It is clearly mentioned in the Indian Evidence Act, and it says matter directly and substantially in the issue. Here, directly means immediately or without any intervention. The word substantially implies essentially or materially. Am I right? Directly or substantially. Directly means without any interventions, no other if and buts. The substantial implies, okay, there's some if and buts are there, and essentially or materially it come out. Matter collaterally and incidentally in issue. It is just contrary to the matter directly and substantially.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तब जय गाथा
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।